Thanks, Susan. Hey, how many people were on the webinar version of this that we did in October? Okay. Well, it's good that we didn't recycle the program like we threatened to. we were debating, the live program thing is relatively new again post-COVID, and we were debating whether ties were required, and we decided if they are, we're not wearing them anyway. And so I'm glad to see we made the right call. There's not a single tie in the room, is there?
Not one.
Yeah.
That's
okay.
awesome. COVID killed ties.
COVID killed ties. So this is who we are. I'm Mark, he's Paul. I've had 3 distinct careers in my life. I was a high-end commercial litigator for about 20 years. I got sucked into firm management and was our firm's managing partner for 11 years. And then that ended about a year and a half ago, and I now serve as one of our firm's in-house counsel. Also lead our legal ethics and professional responsibility practice. We can defend you, we can prosecute for you. I act as an expert witness, and obviously I write and speak quite a bit. Paul is, as said, the managing partner of our Dallas and New York offices, and also does litigation. Tell us a little bit about yourself, Paul.
Yeah, so I'm a complex commercial litigator. I litigate all over the country, some in London, some in East Asia. It's so good to be in a live event. This is my first live CLE that I've done. I've done like 30 on the web in the last 3 years, and it's nice to actually see real people and get some feedback, and don't be afraid to laugh. Because you can't hear laughs on a webinar. But so I've been practicing in Dallas and New York 30 years, and I was the managing partner of Lackey Hirschman, a firm I founded for 17 years. So between the two of us, we have 30 plus years in firm management, which involves a lot of ethics.
Yeah, don't hold that against us. So here's what we're going to do for the next hour. Susan mentioned Dear Ethics Lawyer. That's a column that I publish by email twice a month. There are short questions and answers following the model rules, and there's an important caveat about that I'll mention in a minute. So they're not state-specific to any particular state, but they do provide answers to, hopefully, questions you find useful 52 times a year, or excuse me, 24 times a year. And not a math major, obviously. So these will be in Q&A format, and then we'll talk about. Now, the caveat I want to deliver is these answers that I will give will be according to the model rules. Texas doesn't necessarily always follow the model rules.
As a matter of fact, it doesn't. So they always say Texas is a whole different country. It's especially true in the model rules. Texas has adopted some. The ethical rules in Texas are guidelines. Courts cite them as guidelines. They're not rules. They're not a basis for a case against an attorney. They're not a basis for anything except disciplinary actions. So really in Texas, when you get down to what you're ethically required to do as a lawyer, it's the case law. And so as we go through the model rules, to the extent Texas has a substantial difference, I'll try and point that out. But Texas is odd in that the model rules they've kind of thrown away, said use them in disciplinary proceedings, and they're not even the basis for a breach of a legal duty.
But we assume that many of you are involved with companies that do business in a lot of other states and probably touch those other states, so the model rules are probably pretty relevant to you in any event. One last thing about Dear Ethics Lawyer, if you like this program and you want to get some of these questions and answers on a regular basis, just drop me an email and I'll add you to the mailing list. We have about 6,500 lawyers around the country that get it now, and happy to have as many as possible.
All right, so we're going to get started. Mark, I represent a company in litigation during discovery. May I tell an unrepresented third-party witness that they don't have to speak to the opposing counsel about the matter? And may I ask one of our business people to reach out to third-party witnesses with which she has an ongoing relationship and ask them not to speak to opposing counsel about the matter?
Okay, so Paul, Model Rule 3.4F is a rule that I'm sure we're all familiar with. It prohibits a lawyer from asking a third-party witness not to speak to opposing counsel. And the theory behind it is obviously we want the information to come out, and we don't want legitimate discovery to be hidden by leveraging a witness not to speak to someone. Now, that doesn't mean that the witness is required to speak to opposing counsel, and that has created this important nuance about whether it is okay to say, it's not okay to say, Amber, would you please not talk to opposing counsel? That's not okay. But what if I just said, Amber, you don't have to talk to that guy. He's kind of a jerk. And that's the question that's framed here. There's a little bit of a mixed bag here in the cases around the country under Rule 3.4. Most state ethics opinions, the majority rule, is that it's okay to tell the witness they are not required to speak to counsel, as long as you don't create any other, you don't add more to it. You don't create any other deceptive things that go along with that by implying that somehow you're providing this advice to them in a disinterested fashion, that by misleading them about the role that you're playing, you know, that you're not the opposing counsel and you don't have an interest in this. And also, if there's some reason they should have counsel before they talk to anybody, you probably got to tell them that too. All of this is covered in a variety of state ethics opinions. Most say, as for example, the DC Ethics Opinion 360 from 2011, that it's okay in that environment where you're not adding any baggage to it, that it's okay to tell a witness that they're not required to talk to opposing counsel. In the DC Ethics Opinion, for example, the issue was whether the lawyer could tell their own client's treating physician not to talk to opposing counsel. And the opinion held that you couldn't do that. You couldn't tell the treating physician not to talk to opposing counsel. Treating physician was not an expert. He was simply in the capacity of a witness, and therefore you couldn't do that. But you could tell the treating physician you don't have to talk to opposing counsel, and that's an important nuance here going forward. Yes, a question. Okay, so I'll repeat the question just so it's on the video, which they're recording for this. What if the lawyer's just minding their own business in their office and the treating physician calls them and says, I got a call from or I'm getting ready for my deposition. What do I do? Can you help me out here? What do I say? Am I paraphrasing that?
Even before that, should I go?
Should I go? Should I go to the deposition? And so I think there that it's really not exactly within the scope of this particular rule. I think Rule 4.3, when you're talking about fairness to third parties, I think the issue there would be not to create an expectation with the treating physician that you're giving them legal advice as their lawyer.
Yeah, I think one of the keys in all of this is to make sure if you're going to talk to unrepresented third parties, you need to start off with, I don't represent you, or I represent company X. If you do that, then under most of the ethical rules, and Texas, this is one Texas kind of follows, has the same ethical rule, no directly on point ethical opinions. But if you start off with, I don't represent you, I think that gets around about 99% of the ethical problems with whatever you say following that.
Yeah, now I think you probably could draw the line at you shouldn't tell the third party witness not to go to their deposition, because that really does kind of wade into this Rule 3.4 issue of telling them not to talk to the opposing party, not to testify. But you certainly could, in that environment, once you make it clear you don't represent them, you could tell them, you know, have you ever been deposed? Well, here's how this will go. You could give them some factual information, as long as you're not misleading them about your role in the matter.
Now, does it change if it's a former employee?
If it's a former employee, yeah, actually, we may get to that here during this program, but the question is often, there's really two questions. One, what can you tell them about interacting with opposing counsel, and also how do you protect your interest in confidential information or privileged information that they have in their head that actually belongs to your client? On the first front, they are, as a former employee, they are nonetheless a third party, and so you cannot tell them not to speak to somebody, not to speak to opposing counsel about the matter. However, you do have a legitimate interest in protecting confidential information or privileged information of the client, and you could legitimately say, look, I can't advise you not to speak to the opposing party. I can tell you you don't have to, but just know that when you do speak to the opposing party, you should remember your obligation to protect privileged or confidential information and not give any, trade secret information, et cetera, to opposing counsel, at least without being told by a judge to do it. And that's a legitimate instruction.
Does the opposing counsel language have any bearing on that rule? Like, what if you're unrelated to the matter? Your neighbor walks up to you and asks you, and you tell them, don't talk to either counsel. That rule still apply?
That's a great question. You know, I've never seen that case. I've never seen that asked, but you know, it doesn't say the Rule 3.4F does not phrase it in terms of. Well, it does say opposing counsel. It does say that. I was going to say, I think the better position there would be not to tell them. It would be to treat it the same way, not to tell them, not to instruct them not to talk to them.
I think you have to be careful, and this is back to that representation. If you give them that advice without saying that you don't represent them, you've now created an attorney-client relationship with that person.
Presuming the disclaimer,
Yeah.
Yeah, that's a
In-house
separate issue.
context, right, I guess even if you layered it, you still have potential issues running through someone else, but that's a conversation a
Well-
non-lawyer could have.
And we'll talk about that, running it through someone else here in a little bit. I think if we get to that question, it's kind of down the road.
Yeah, well, there is. I mean, it really does apply here too. You know, the second part of this question was, can I ask one of our business people to reach out to third-party witnesses who they know? You know, look, John, I know you have a vendor relationship with Julie. Could you reach out to Julie and ask her not to talk to opposing counsel about this matter? Rule 8.4, which is the rule that defines misconduct in the model rules, makes it misconduct to try to do through somebody else what you can't do yourself. Now, there's some caveats to that, one of which we will get to here in a little bit. But so the answer is that doesn't help you. You can't ask your business person to do what you can't do, at least in this context. Okay?
On to the next one.
Question one.
Question one. Question two. I'm in-house counsel for a company and filled a steady stream of requests for legal advice from various business department heads. And looking at internal emails, I'm finding that often the advice I provide is quoted or relayed to subordinates of those business department heads, usually without the presence, in person or by email, of myself or any other lawyer. Does this potentially waive privilege protection for that advice?
Yeah, so this is, I assume this is something that probably a phenomenon that you're all familiar with. It's certainly a very common one in practice, especially when sorting through emails that are responsive to discovery requests and seeing how far privileged advice has gone out into the field among the client's employees. And the answer is it depends. It really does depend. There are two categories or lines of cases about how far privileged information can be conveyed outside the scope of a direct conversation, whether electronic or in person, with the lawyer. And one line of cases is it's okay that that's conveyed through non-lawyers who have to other non-lawyers who have a need to know it. Another line of cases is a little broader and says it's okay that the communication is conveyed to a group of employees at least whose jobs relate generally to the information relates to their generally to the employee's corporate duties. So if it all kind of comes back, do they have a reason to know that privileged information in order to implement the legal advice that's been given? And generally speaking, if that's true, then the information can be passed down the chain of employees as far as that's true. The problem is in business environments, sometimes the people get added to email chains and the information goes a little too far. And that's where the rubber meets the road in terms of whether, remember the general rule about privilege is the presence of any third party in the communications scheme works a waiver of privilege. And so if you get too far down the line and some employee in the company who doesn't have any relationship to need to know that information or it's not part of their job, they start getting the information, that's when you have a real risk that somebody's going to find a subject matter waiver on the content of that communication.
And what if it goes the other way, Mark? What if the lower level employees are gathering factual information, passing it up through non-attorneys to eventually potentially be used by the attorneys? How does that affect this?
Yeah. So it's really the same thing in reverse, but the same rules apply. So let's say you have a working group in your business who says, we're seeing this phenomenon occur. I'd like all of you to gather the information about the instances it's occurring, and then I'm going to take that to our lawyers and get some legal advice. In that circumstance, where information is being gathered within the company by non-lawyers, but for the purpose of seeking legal advice, that's generally held to be privileged. Again, if the people who are gathering it are necessary to do the gathering. And so even if you have no lawyer involved in that initial communication about gathering the information, generally that can in most places will be privilege protected as long as it's then conveyed to the lawyer for purposes of giving legal advice. So it's really the privilege applies to communications for the giving of legal advice or for the receiving of information to base legal advice on, and it works both ways. It can work both ways. It can also be waived if the wrong people end up involved.
And as a practical matter, the sooner you start copying some attorney on those emails, the easier it's going to be to convince a judge that they were privileged, right? If you go through 15 levels and there's never been an attorney, then maybe a judge is going to be like, I don't know if that's privileged. The sooner you start seeing attorneys, even on the CC line, the more likely a judge takes a step back, raises his hand, and says, no, this sounds like normal privileged information.
Yeah, but always remember the mere addition of a lawyer, we run into people all the time, the mere addition of a lawyer to the chain, especially on the CC line, does not make it privilege. It still has to be a request for legal advice in some way, or a providing of legal advice in some way, shape, or form. So.
All right, on to the next one.
Yeah, let's do it.
Question number 3.
Oh, wait a minute. Okay.
There you go. Joint representation. I'm in-house counsel for a railroad, and we have a dispute with the shipper who has fallen on hard times and owes us a lot of money. The transportation law firm I would like to hire also represents 3 other trucking companies which that shipper owes money to. That firm wants to jointly represent all 4 of us in pursuing an action against the shipper. They say it's going to be more efficient, it's going to save fees, it's going to save cost. What are the ethical issues here?
Okay, joint representation issue. This can be very practical and a pragmatic solution to efficiently manage something that would otherwise cost a fair amount, especially where the issues are common. But there are some ethics issues to work through in joint representations, and I'll run through some things you should think about. First, at the outset, obviously, you should consider the possibility there may be conflicts between these various transportation companies. Things like the size or validity of their respective claims against, or defenses if it's a defense situation, that would put the law firm in a conflict situation and have to withdraw down the line. This can occur particularly if it's a zero-sum situation. Where in this case, the shipper that you're talking about only has a defined pot of money, and the claims of the group that would be part of the joint representation exceed that defined pot of money. Then, if not otherwise accounted for, there could be a conflict down the road about whose claim is better, or whose claim is more valuable, or how the monies are allocated. That obviously brings another issue into play. If the funds that are recovered are potentially limited, then you really need to work out up front how those funds are going to be allocated and when. Is it first in, first out, or first in, last out? What's the rule about how monies that are received going to be allocated over time?
And it's really important, I think, you do that up front. Once you're engaged, the lawyer can't represent one of the clients against the other one in negotiating how the monies are going to be distributed, right? So if you don't have that discussion up front, you almost can't have that discussion as a lawyer down the road. But if up front you say, hey, there's 4 of you, you guys need to decide internally how you're going to divide up the money if we have one aggregate settlement, and they do that up front, then you're a lot less likely to get in trouble. Once you're engaged, you can't represent one client against the other one in negotiating what percentage of some settlement they're going to get.
Exactly. You don't handle it up front. You've almost guaranteed a conflict. Another category of issues relates to how information during this representation is going to be handled. Will the information the lawyers gather from each of these potentially joint clients be shared with all the other clients? If not, then you're creating a situation where there may be relevant information that the law firm ends up with that one of the parties wants to know and should know, but they don't have authorization to tell them, and that too can create a conflict. There needs to be another information issue is there needs to be something worked out. If nothing, for lack of a better word, a joint defense or common interest agreement to preserve privileged communications and some discussion about how that's going to happen in the initial engagement. And you need to figure out, are there going to be, is the law firm handling this going to have what we call material limitation conflict under Model Rule 1.7A2? Is there an issue? That's when the lawyers of the law firm may have an interest as to one of these clients that is stronger than the other clients and create a situation where they might at least be perceived to have the motivation to favor a client. For example, in this scenario, for example, if the law firm is a long-time firm who's represented Railroad, and Railroad is one of their larger clients, and the trucking companies that are being added on to the joint representation are one-shot clients, is there a possibility that if there is an issue here that implicates different positions, that the law firm could be perceived to favor their longtime client over the others? Those things need to be examined and discussed and dealt with up front. Also, what about an aggregate settlement? Who's going to decide what kind of a settlement would be agreeable to the group? That all needs to be hashed out and dealt with in the engagement up front. So these joint representations are certainly can be very productive things to engage in, but there's just a little bucket of ethics issues that need to be accounted for, and all of them can and should be accounted for in the initial engagement process.
All right, question number 4. What are we at? Corporate family conflicts. I'm the Associate General Counsel for Universal Shipping Company, a large transportation conglomerate. We have a lot of subsidiaries, including some that are engaged in ancillary businesses and do not have Universal in their name. Today, I discovered that a law firm that is currently representing Universal Shipping in a transactional matter also represents a commercial party in a contract lawsuit against Smith Food Services, Inc., an ancillary business that we bought a few years ago and is a wholly owned subsidiary. Smith provides food and beverage services to airlines and railroads, and we left its management in place so it functions as a freestanding subsidiary. Does the law firm have a conflict?
Okay, corporate family conflicts, a swamp of issues that are highly fact-intensive. In this scenario, we've purposely set it up so it's right on the line. The Smith Food Services obviously doesn't share the same name, so there's less of an expectation that this would have, if it had been Universal Food Services, maybe that would have been a little easier to spot going in. We've also set it up so it's a completely different line of business, and that it functions as a freestanding subsidiary. In other words, its operations aren't integrated in with the corporate parent. And so in this scenario, most likely we've set it up in a way that this may not be a conflict. Now there may be facts here we're missing, But where you have completely unrelated operations that aren't integrated, and there's not, one of the facts we're missing is what was the engagement letter with Universal Shipping? Did it provide that the law firm agreed that any subsidiary of Universal Shipping was going to be considered as a client for conflict purposes? If it did, then this would be a problem. If it didn't, then that's a factor that runs the other way. In general, in these sorts of situations, the factors that are looked at, there's a case. Yeah, so there's an ABA opinion 95-390 that talks a little bit about this, but in general, under Model Rule 1.7, comment 34 says the representation of a corporation or other business organization does not necessarily mean representation of a constituent or affiliate organization such as a parent or subsidiary.
And this is one that Texas is a little bit different because Texas did not adopt comment 34. So in the model rules, you have a pretty clear representation that you don't necessarily represent the affiliated companies up and down the parent chain. In Texas, that comment's not there at all. So it doesn't say one way or the other whether Texas would follow that rule, but it's a little bit different because this rule gives you a little bit of cover that if you're in Texas, you're going to have to dig a little deeper.
Yeah, so, and then within the framework of the model rules, it goes on to say, though, that it's a fact-intensive inquiry. Facts can suggest that affiliates should be treated the same as the parent, and obviously to the extent the lawyer and the client have agreed that they should be in the engagement letter, then that's an issue too. There's a very useful case. It's called Gartner, Gartner. It's out of the Southern District of New York from January 2022. It's an excellent discussion of these corporate family conflict issues. This was a case where Norton Rose Fulbright was representing an insurance company related to its denial of a claim related to cancellation of events during COVID and insurance coverage for that. And the plaintiff in the case who was making the insurance claim tried to DQ Norton Rose on the theory that Norton Rose Fulbright was also representing, at the same time as defending this claim in the United States, was representing an affiliate of theirs in Australia on completely different things, but the claim was, look, this is a fairly integrated affiliate of ours. Therefore, you shouldn't be allowed to be adverse to us in the United States, having represented this other affiliate in Australia. And so the Southern District of New York looked at this, and they reviewed several of the cases, and they said, the factors really are two. One, what's the extent of operational commonality, the integration of the two entities, and what's the extent of financial dependence of one on the other. And they looked at, in this case, that although the companies were formally separate as separate corporate entities, many of their operations were centralized. They had central management of their finance departments, central management and leadership of their information technology, and most importantly, centralized legal department. And it looked at that, and also looked at the extent of financial interdependence between the two entities, and said, yeah, this is a conflict. And so, in the absence of anything else, we would disqualify Norton Rose Fulbright from this. Now, then, in an aspect of the case not related to this point, they said, but wait a minute, y'all kind of waited too long to bring this issue, And there's no real harm. You don't have any. Norton Rose doesn't really have any confidential information that relates to this particular claim. So on equitable grounds, we're not going to disqualify Norton Rose in this particular instance. But there is a conflict from representation to the corporate family. So it's a good case to look at in terms of the factors of the degree of integration required between a parent and a sub or a sister company.
All right, on to number 5. As a result of the pandemic, I've gotten very comfortable not wearing a tie and working remotely. And my clients don't seem to care as long as I'm responsive. I recently purchased a vacation home in another state, and based on my experience, I'd like to spend a substantial amount of time working from that vacation home. I'm not licensed to practice in that state. I don't plan on opening an office there or seeking or serving any other clients in the state. All the client relationships I currently serve are centered in states where I'm licensed. Is this plan workable?
Yeah, this is a development that really is happened as a result of COVID for the most part. A lot of the the ABA for one, and a lot of state ethics opinions have come out sort of sanctioning remote work, at least in the context of where you are, and it's on this slide, invisible as a lawyer. It has become a buzz phrase in the remote work state. So that means if you're simply working from a state where you're not doing any work in that state for any clients in that state, you're not holding out yourself as a lawyer from that state, and you don't have any trappings of having an office in that state. You don't have a website, ads, cards, etc. You're there, but you're invisible to the outside world. ABA Formal Opinion 495 from 2020 says, yeah, that's okay. You can do that. Vacation away or whatever. And so that's become, it used to be fairly controversial. That's become, at least with the majority of opinions, state ethics opinions that have dealt with this, that's become the rule. Now, the nuances where people get in trouble with this are where, let's say, the company does have an office in that state. How do you deal with that? Does that put a different angle on it? Well, it does if you're officing in that office. Then you are no longer invisible. You actually have a presence in the state. Arguably, it does if you are practicing law in that state by advising the company's office in that state.
So you're saying the law firm, not the client. When you said the company has an office in that state, you mean if your law firm happens to have an office in that state, but you're not licensed?
Well, but this being an in-house group, I'm extending it to that too. If for example, you're working remotely as corporate counsel and your company has an office there, then you need to be careful about acting as a lawyer in that state by advising the company's office there.
So Texas has not adopted a general remote work policy rule and the ethical rules yet. The closest is kind of older pre-COVID opinion that talks about working in a state where your firm has an office and you're not licensed. And if it's just kind of incidental, you go into the office a few times, it's not a problem. I think the problems come when you go into an office regularly in a state you're not licensed in and you're practicing law, or when you start meeting clients. It's that invisible as a lawyer. You're not invisible as a lawyer if you're meeting clients even for lunch in that state, and you're not invisible as a lawyer if you're going into that office regularly, even though you're not licensed in that state. And I think that's probably, although there's a movement, and we suspect that movement's going to accelerate, and maybe in 5 to 10 years this will be a silly conversation because there'll be some kind of universal licensing. But as of right now, some states look at it closely. Texas hasn't made a decision. If you're in New York, for example, they're going to look at reasons why they should tax you. So the more time you spend in the state, the more time you spend in the office meeting with clients in the state gives the New York taxing authorities additional reasons to find revenue being generated out of New York and try and tax your firm. But it's this sort of invisible as a lawyer, which is a term that didn't exist, I don't think, before COVID, and I don't want to be invisible, but that's really the test. If someone could come to that state and meet with you as a lawyer, you're probably not invisible as a lawyer.
Yeah, and this is very much a moving target. Not every state is on board with it. Certainly, if you plan to spend an extended time in a state working remotely, you should check that particular state's rules and opinions. But it is definitely moving in the direction of allowing more activities, or at least not getting worked up over temporary presence in states for activities. I think, as Paul mentioned, universal licensing. There are groups within the ABA talking about this right now. So far, it hasn't caught fire. There's still a lot of state-by-state interest or protective desire happening out there. But I think probably in the lifetime of people in this group, we will see that.
Yeah, well, and it's rare to even find a company that's only in one state these days, and it's getting
Right.
rarer to find a law firm past a certain size that's only in one state, right? So these are problems that I think we're kind of struggling with as a profession that might be disappearing, and COVID really has rapidly convinced a lot of states that they want to encourage the lawyers to come spend the money to buy the house in Vail but still work in Texas, right? So I think you're seeing a big movement, but it's not clear yet that that's going to be allowed in every state.
Now, I'm going to talk about an exception to that here in a second, but the fair application to an in-house lawyer would be you shouldn't go establish yourself to work remotely pick a state and then advise the company's office in that state from that state, because then you're practicing law in that state. Now,
If I'm sitting in Texas, it's okay, but if I'm sitting in another state now, it's not okay.
yes, the answer is yes. If you're sitting in Texas and you're talking where you are licensed and you're talking to somebody in California, then fine. There's no issue with that. The question is your physical presence in California may create a different answer to that question. And by the way, California is a completely different animal here. I mean, they talk about Texas being another country. California is
Another planet.
several countries. They're also
The problem is the ABA rules don't differentiate between in-house counsel and outside counsel. And so obviously in a world where so many companies are multi-state and so many issues are multi-state, we all give a lot of advice that's in states we're not licensed in. But under the rules, the way they are now, if you give that advice sitting in a state you're licensed in, no one ever cares. If you sit too long, if it's a weekend, you're in California, but if you're out there for 6 months, you're going into the office every day and you're advising California clients, you probably are in violation of the way the rules are, but it's shifting and becoming less and less a concern almost on a day-to-day basis.
Yeah, that was the other thing I was going to say. The other sort of exception to this concept, Rule 5.5, which is the rule that generally concerns multi-jurisdictional practice. In most states, and again, this one is highly state-specific. It is not adopted the same way in every state, or even in 2/3 of every state. There's a lot of variation. In most states, 5.5 has an exception for what you would call temporary incursions. In other words, what Paul said, if you go out there for a short visit, can you do something without running afoul? Yes. In many states you can, not in every state, but in many states you can engage in a temporary practice within the letter of whatever rule is in place in that state. So it's a murky area.
Is any state going after like in-house attorneys on this kind of stuff?
Yes.
Or focus more on
Yes.
law firms?
No, they are going. I have represented in the last 5 years probably 25 in-house lawyers who have been called by disciplinary authorities to explain why they have an office in a state where they're not licensed.
Is it California?
No, not 25 lawyers in the Midwest. It is a real issue. Okay, didn't mean to scare anybody.
Yeah. In 5 years, it won't be an issue. All right, let's go on to number 6, advanced waivers. Our law department has a go-to outside law firm for our corporate M&A work. Because of their expertise and knowledge of our business, we want to use them in a big transaction in which we would make an unsolicited offer to purchase a controlling share of stock in Company B. We approached the law firm about the matter, and they disclosed that their office in another city has a small and unrelated property tax appeal for Company B that's not completed, but their engagement letter with Company B has an advance waiver that on its face would allow the firm to be adverse to Company B in unrelated, non-litigation matters. I want to use the firm, but I don't want to make a change later if for some reason the waiver doesn't hold up. How comfortable can I be?
Advance waivers, okay, very popular subject these days. They're really not special. An advance waiver is just a waiver that is provided in a different time frame than typical. They are a variety of a standard Model Rule 1.7 conflict waiver. They are effective if these 4 things, which are specified in Model Rule 1.7b, are present. The lawyer reasonably believes that she or he can competently and diligently represent both clients. The representation isn't prohibited by law. It's not the same thing. It's not the same litigation before a tribunal. You can't be on both sides of a thing. And each affected client has given informed consent. Now, when advance waivers become an issue is typically the issue usually is whether legitimate informed consent has been given. Let me see. Yeah, here we go. Did the client understand at the time of the agreement what they were agreeing to? What future level of adversity could they experience in what kinds of matters, et cetera? We've all seen, I'm sure you've all seen proposed engagement letters from law firms that have you waiving every future conflict of any kind that doesn't involve the same matter, right? There are lots of varieties of advanced waivers that are sought. And in the cases that deal with with the enforceability of advanced waivers, the number one most important thing is the level of sophistication of the client. If you have a sophisticated corporate client who hires lawyers regularly, then some of those very broad waivers are often enforced. Sometimes they're not if it's a subject matter that's so esoteric or so out there that there was no reasonable likelihood that the client understood what they were agreeing to. But mostly when it's a sophisticated client, advance waivers are, at least these days, being enforced pretty regularly. On the other hand, if the client is less sophisticated, somebody who doesn't hire lawyers all the time, then they tend to be enforceable only if there's been some specific discussion with the client about the kind of thing that may come up later. Look, we're representing in this litigation matter, we could be opposite you in a real estate transaction or an environmental matter or, whatever. In the less sophisticated circumstances, the cases look to see whether the consent was informed in the sense that the client knew what they were getting into. Another thing
Can you back up one slide real quick?
Yeah.
So Texas has adopted the advanced waiver rule in general, but not specifically sections 2 and 3. So the rule in Texas is 1 and 4, but the analysis is largely the same. It doesn't say not prohibited by law or not in the same litigation, but when the courts analyze it, they use those same factors. So even though it doesn't specifically adopt 2 and 3, the Texas rule is largely applied the exact way that Mark's talking about.
If you think about advanced waivers, they really serve an important purpose. It really kind of links the law firm's acceptance of the matter and their corresponding ethical duties to the client with the client's willingness to accept the firm's ability to work for other clients in whatever unrelated matters are specified. And so it's if you think of it, it's kind of like an economic transaction that allows ultimately creates access to justice in the sense that clients have access to firms for expertise that they're not conflicted out of because of an advance waiver. But the important thing again is that everything be an informed consent, that you know what you're getting into. And as a corporate lawyer, when you get one of these, and many of you probably also have outside counsel guidelines that deal with them. That's a very common thing. The important thing is to make sure that you understand what you're getting into. One other nuance about advanced waivers that I think people don't understand is they're not permanent. A client can always revoke an advance waiver, just as the client can withdraw any particular waiver. Now, if there's been some action taken by an adverse party or a law firm in reliance on that, there may be an estoppel or a waiver of waiver argument, but if failing that, you can always cancel it. So it's probably enough on advance waivers.
All right, number 7. I'm an in-house counsel at a growing company. However, as I rise through the ranks, I'm gaining the confidence of others and often find myself being asked to attend more and more business meetings as a business person, not a lawyer. This has not been an issue for internal meetings, as there's typically a clear delineation between when I'm raising business questions versus providing legal advice. However, recently I was asked to attend an external meeting between a senior executive of my company and a senior executive of another company that we are thinking of doing business with. The senior executive of my company made it clear he's asking for me to come as a business person, not a lawyer, because he wants me to learn more about the business. I'm concerned because even though I'm attending as a business person, my actual title, my company role is in-house counsel. The other company does not have an in-house counsel and likely will not have a legal representative at the meeting. Given the possible ethical issues of attending a meeting where the other party will not be represented by counsel, is there a way for me to attend without running afoul of ethical rules or requiring the other company to bring a lawyer?
Okay. This may seem like a convoluted example, but a corporate lawyer actually sent this to me 2 weeks ago as a legitimate question. Do any of you ever wear a different hat? Do you? Yeah, so it does come up. It's an interesting question. It's a model rule 4.2 question. Rule 4.2 is that rule that prohibits you from communicating with a person that you know to be represented by other counsel without the consent of that lawyer. Again, it's not just the consent of the client, it's the consent of the other lawyer that's needed. But there's an important sort of qualifier in the midst of Rule 4.2, and that is this prohibition applies when you are representing a client as a lawyer. And so, so there's really, in this situation, you've got two questions. One is the other party going to show up with, this is the obvious one, is the other party going to show up with a lawyer if that's, or has counsel already? If the answer is no, then there's really no issue regardless. And the second, which is the key to this hypothetical, is are you representing a client as a lawyer? If you're showing up as a business person, I would say no, you're not. And there's case, fortunately for me, there's case law that agrees with me. There's a Northern District of California case called HTC Corp. From 2010, and there's a case from Connecticut, In re Rock Rubber. It's actually a bankruptcy case from 2006, and it basically says that if Rule 4.2 is not violated when a person that happens to be a lawyer is meeting with unrepresented people, or excuse me, with represented people, with people who do have counsel, but meeting with them not as a lawyer, meeting with them as a business person or in some other capacity. In this case, one of the cases, the lawyer was acting as a bankruptcy trustee, not a lawyer. Now, that's a finer line to draw. And there's actually a case from another state that disagrees with that, but it's out there. So as a practical matter, what do you do in this scenario when you're attending a meeting, you know the other side has counsel of some sort, you don't know whether they're going to show up? One possibility is simply to communicate with one of their lawyers, if you know who it is, and say, look, I'm coming to this meeting, but I'm not a lawyer. You can come if you want. Or I'm not coming as a lawyer. You can come as you want. You can come if you want or not.
Don't lie to them. Don't tell them you're not a lawyer. That's bad. That's bad.
And the other thing is for you or for your client to advise the other client that, look, I'm bringing I'm bringing Joe, but Joe's not coming as a lawyer. He's really coming for business purposes. Bring your lawyer if you want, just to clarify the role that you're filling before you show up, or at the very least at the beginning of the meeting, say, look, I'm a lawyer, but I'm not acting as a lawyer. And then, by the way, don't do it. Don't act as a lawyer at the meeting. And if that's true, you're okay. This is not prohibited by the rule.
Can I ask a quick question?
Yes.
So when the other side does not want to include their lawyer because they don't want to incur additional costs, I can't remember, who has to authorize you to talk with them without their counsel? Their counsel, or can they do it?
So the question is, if the other side doesn't want lawyers to show up at the meeting, or at least
Like,
doesn't,
I'm happy to talk to you, let me ask you all the questions I want.
Right.
Even though you say, like, I can't.
It-
Advise.
then can you still show up at the meeting?
And they drop them for communication, and they call you without their counsel. I mean, how do you?
Right. The line here is, if you know they're represented, their approval to communicating with them is not sufficient. You have to have their lawyer's approval to communicate with them.
And that's really, the model rule actually says that
Yeah.
specifically. I mean, I think a lot of times it's a communication, as long as you tell the other lawyer, hey, your client is asked to communicate directly with me, and they don't write back, hell no, you're probably okay. But the model rule does actually require the lawyer, not just the client. So the client can say all they want. I don't need my lawyer here. I don't need the money. I want to save the money. You're still definitely required under the model rule, and the model rule is adopted in Texas, to get the lawyer to agree that it's okay.
That's a great question. So you're acting in connection with this meeting, or the subject matter of this meeting. You're not acting as a lawyer, or at least that's.
And I think it's even
that's
more
the theory.
complicated, because he and I actually had a little argument about this, a nerdy ethics lawyer argument, because I said, once you're a lawyer, how are you not a lawyer? Right? You know the legal concepts, you've read the cases, you went to law school, you got a degree, you got all those things. You step into a meeting and you say, now I'm a business person, and inevitably, every business dispute, conflict, communication is going to have some legal element, right? So from my perspective, what I was saying to Mark earlier is, I don't see how you can ever just say, I'm a business person today, once you're a lawyer, because you're always going to be thinking like a lawyer. And then, like you said, when a legal issue comes up, and then later you want to say, well, I had this communication with my executive, but it's privileged because I was acting as a lawyer, and they're like, wait a minute, you said when you walked into the meeting you weren't a lawyer. I mean, I think it's a really fine line to draw, and I think it's a problem, right?
Well, now keep in mind, Mr. Lackey, that we're talking about privilege here. And privilege applies whether you're a lawyer or not a lawyer when you're giving or receiving legal advice. And if you show up at that meeting, or you're having a conversation around the topic of the meeting, not as a lawyer but as a business person, if you're not giving legal advice, or if you're not getting information for the purpose of giving legal advice, there's not going to be a privilege. And so, yes, by setting yourself up, or having the company set yourself up as a business person, not a lawyer in this context, one of the things you're giving up is privilege protection.
And as a practical matter, we can all laugh about CCing a lawyer, adding a lawyer, saying you're a lawyer, but judges actually, when you're a judge and you hate discovery disputes, and you hate privilege logs, and you're fighting over whether something's privileged, and someone shows a ray line for a lawyer, 99% of the time the judges are going to say, oh, it's probably privileged. And so it actually does matter. I think the optics might matter a little more. They might not matter exactly under the ethical rules, but in the real world, judges don't have a lot of time. They hate discovery disputes. They certainly hate the subset of discovery disputes over a privilege log. And if you can show a connection to a lawyer, most judges are just going to check the box on that.
All right, we probably have time for one question before we, expire.
Let's do the next one. Number 8's a good one.
1 o'clock, right? Okay.
You wanna do number 8?
Yeah,
That's a
let's
good
do
one.
number 8.
All right, so just after reaching a settlement agreement at mediation, but before the case is dismissed, our company discovered a bunch of additional material documents responsive to discovery requests that were not timely produced. The company doesn't want to disclose them now unless absolutely required because of the settlement agreement. It's clear the company representatives did not know of the document, so they weren't hiding them until the recent discovery and acted in good faith in the earlier production. May we or must we make a disclosure to the court or opposing party or produce the documents?
Yeah, so this is kind of a thorny one. You've got it's clear that if this had happened earlier in the matter, before there was a settlement agreement, you would obviously have to supplement the discovery. You can't, otherwise you would be concealing information in violation of Rule 3.3. If it happened later, after the whole thing was over, the case was over, the case had been dismissed, settled, everything is gone and done, if your client had not committed a fraud in doing it, well, actually, even if they had, because it'd be a completed fraud, at that point, Model Rule 3.3 requires you to take remedial measures if a lawyer knows a client is engaging in fraudulent or illegal conduct. As part of
if the documents were discovered after, you've signed the deal, the court's dismissed it, now you find documents that show it's completely untrue, the basis of the settlement.
Right.
You have no legal duty as a lawyer to bring those to the tribunal or the other side, right?
At that point, the client there isn't an in-progress fraud or illegality, crime happening, and so you have no mandatory obligation to make a disclosure there. There is, however, in the rules, and this is sort of beyond the scope of this particular question, there is a permissive disclosure if your client has used your services to commit a crime or fraud that will allow you to make a disclosure, but it does not require you to make a disclosure, which opens a whole other bucket of worms, that if a lawyer may make a disclosure and doesn't, does that somehow make them an accessory after the fact?
And there's an additional nuance.
Get
in
ethics
Texas law.
advice if that situation ever
Right.
ever visits you, and we're way beyond this.
Right.
We'll go another hour on that question.
But there's one other little caveat under Texas law. Texas law adopted this model rule, but they added the words on access in anticipation of a dispute. So in this scenario, you've settled the case, even though the court hasn't dismissed it, you're probably not in anticipation of dispute. So under the Texas ethical rules, I'm not sure you any longer have a duty to turn over those documents, but under the model rules, prior to the case being dismissed, Mark tells me he thinks you do.
Yeah, probably. So let's get back to the question that was actually asked. You've got this, you're sitting here, sorry for that little detour, you're sitting, we digress, you're sitting here and you've got a mediated settlement, but the case has not been dismissed. The case is still technically pending yet. And so where does that put you? Rule 3.3, candor to the tribunal, requires you to take remedial measures until the conclusion of the proceeding. And so what is the conclusion of the proceeding? I think you could make a fair case that dismissal of the case is conclusion or entry of judgment, whichever is going to occur in that particular forum, is arguably conclusion of the proceeding, and that up until that time you may have an obligation to, for example, supplement discovery responses and maybe take other remedial measures. This situation could be avoided, and this is maybe an obscure practical point to put in your bag of tricks for any mediations that you participate in. One way this could have been handled is to have as part of the mediation agreement that all proceedings and obligations are stayed and done pending dismissal of the case, but we're not going to, any discovery requests, neither side has to supplement or do any additional work to comply, et cetera. And that can all be phrased, because it'd be true, that can all be phrased, at least unless you're trying to hoodwink somebody, it can all be phrased as a practical solution of avoiding expense at the time of mediation. Just make that part of the mediation agreement. And then if something comes up between then and the time the case is actually dismissed or the money is paid or whatever, you don't have this problem arising.
Yeah, stop looking for documents after you've agreed to the settlement agreement. How about that? Don't give them to your outside
Right,
lawyer and stop
right.
looking for them is another practical tip. Once you've reached the settlement agreement, don't find the secret documents.
Yeah.
I think we might have.
So
hit our
that's
time.
about it. So questions, disputes. Do you think we got anything wrong? You want to argue with us? Anything else? Other questions about things that are unrelated to this that you've always wanted to know the answer to?
All right.
Okay. Yes.
I think we want to go back to the multiple jurisdiction.
That's the trickiest one.
Our company's in 35 states with 50 or 60 offices across the United States and Canada and Europe and Asia. We've got attorneys in the other countries, but obviously most corporations, when they're recruiting attorneys, we don't care where you're licensed, just be licensed someplace. So we're in Texas, we're headquartered in Texas. Most of us are licensed in Texas. Most of us are licensed in lots of other places, but not every one of those states.
Yeah.
And we've got people all over the country too, our internal clients.
Right. So there's again, I want to emphasize this because this may be true about this set of rules more than any other set of rules. There's individual state variability about this, but as a general matter, if you're sitting in state A, you're licensed in state A, you can advise folks about things in states C, D, E, F, and G to your heart's content, at least to the extent that you're competent to do so, right? The issue arises if you're setting in state A, but you're not licensed in state A. That's where the rubber meets the road.
And if you're sitting in there more than temporarily. So,
Yeah.
But what's temporary is not defined. And by the way, COVID's made that a lot longer. It used to be a weekend or a week. Now it's a couple of months, right?
But-
You're like,
Remember
Wrench.
those cases I was talking about where I've represented in-house lawyers? That has been the scenario. Their office is in state A and they aren't licensed in state A. They're licensed in B, C, D, and E, but
but they're going into the state A office every day, and they're doing their legal job from the state A office. I think that's where the
that's the
disciplinary.
question.
My wrench is similar to that in that my office is here, I'm licensed here. But I spend half the month in New Mexico. So I go back and forth
Every month.
every month.
Yeah. So I don't know New Mexico law,
Yeah, neither do I.
so but
And Texas law doesn't have a direct. Texas law doesn't have a direct opinion on this. Texas law has avoided giving a remote work opinion. There's really no recent ethical remote work opinions from Texas law either.
in some states that regular of a presence could be an issue.
All right, we'll get it.
I'm curious with your clients where this is really happening with in-house attorneys, how is this coming to the attention of the disciplinary board to begin with? I was really just surprised to hear that this is happening with that kind of frequency.
Well, in a variety of ways, but I'll give you one example. There are, at least in one major Midwestern city, there is a directory that the Bar Association, the local city Bar Association publishes that has all the corporate lawyers in it. And the disciplinary administrator literally went to that directory and compared it to their license list and discovered, a couple hundred people who happen not to be licensed in that state, and then just proceeded to go, call them all on the carpet.
And that's really state dependent, right? Like Delaware, we know is really protective of its lawyers. I'm kind of surprised. What state was that in? Kansas or Missouri?
Well, I'd prefer not.
Whatever
to
state
say.
it was in the Midwest, I don't think is normally considered that protective of its lawyers, right? So you're in California, you're in
Yeah.
Delaware, you better be real careful. But it can happen. I mean, the
Yeah.
rules are not consistent with how we are practicing post-COVID. And I think they're moving in that direction. But if someone at a disciplinary committee decides they want to, I don't know, get some press, get some fees, get some whatever, it's surprising, but it's happening.
So when you have businesses who are headquartered in Texas, and then you have recruiting general counsel or whatever from across the country.
Right.
Kind of have may be a problem.
If they're going to be physically in the Texas office all the time, they're probably going to need to be licensed in Texas. And I don't think there's really a way to get around that.
Yeah.
Now, what are the odds of getting in trouble? I've not seen a Texas disciplinary procedure on this.
Yeah, no, it's a the question that you raised was a good one. Often it flies below the radar unless you have a particularly aggressive, administrator, basically. So, but, it can be a problem. So, other questions or issues?
Is it likely, is it more of an issue in the state you're sitting in or in the state you're licensed in? Most likely the state you're sitting in, but could it be an issue in the state you're licensed in?
It could be an issue with either. It won't be an issue in a state you're licensed in if you're not practicing there, if you're not sitting there. It's going to be an issue if it's going to be an issue, it's going to be an issue where your office is if you're not licensed there. That's the number one way this comes up.
Usually, whichever location is concerned is the one that's going to apply their own rules, right? So you don't get to pick that. Whoever's concerned is, like, if it's New Mexico, they're going to apply New Mexico rules, even though you're like, I live in Texas and I'm licensed in Texas. And I think we've seen that in, like Texas, for example, one of the questions we didn't get to, has an irrebuttable presumption if a partner leaves a law firm and goes to a new firm that they're going to share confidences, and you can't wall them off. Most states in the model rules, which later in our thing, allow you to wall them off, right? So then now you're in multi-states, and I had this come up in Ohio a couple of years ago, where it was a firm that had offices in Dallas and Ohio. We had offices in wherever we had offices, not in Ohio, but a case in Ohio, two partners went to this firm that had actually probably had confidential knowledge about the case. Under Texas law, that's an irrebuttable presumption they're going to share it, and that law firm is out. Under Ohio law, which follows the model rules, the Ohio judge said, well, because the case is pending in Ohio, even though they're Texas lawyers that went to the Texas office of this law firm that's also in Ohio, I'm going to apply the Ohio model rules, and they walled them off, so they're good.
Well, so thank you all for having us back. I hope this was useful. Again, if you want to get these question and answers like this, in fact, some of these have been already the subject of Dear Ethics Lawyer. If you want to be on our mailing list, just send me an email, send Paul an email, we'll get you on the list. If you have questions like this that come up over time, just a 10-second commercial, we do this for money. That's what our legal ethics and professional responsibility practice does. And we do advise corporate law departments pretty regularly. So anyway, thank you very much.
Thanks.